It is my pleasure to welcome you to the third African Law Seminar. This seminar will focus on Africa and international courts and tribunals. It will highlight Africa's contribution to the peaceful settlement of disputes and the development of international jurisprudence. It is my privilege and pleasure to introduce our first distinguished lecturer, Judge Abdulqawi Yusuf, who will address Africa and the International Court of Justice. Judge Yusuf, you have the floor.
I thank Virginia Morris for organizing this seminar. As Virginia said, this is the third seminar on African law, which is held online. Virginia told me that there are about 1,800 people who registered for this seminar. This is extremely heartwarming for me because we do not usually have so many students attending either online or expressing interest to attend in-person seminars and workshops at the African Institute of International Law in Arusha, Tanzania. So I'm very happy that these online seminars are actually organized by Virginia, are actually attracting more and more attendees who are interested in international law and in the public law of Europe, of Africa. Because today we are going to deal with international law, but in some of the other seminars, we dealt with the public law of Africa or the law of the African Union, and plus the conventions, protocols, agreements, treaties, which regulate relations among African states and which have been adopted by the Organization of African Unity and its successor, the African Union, which, as you know, is the Pan-African organization which exists today. So let me introduce the subject which I'm going to address today. It is the International Court of Justice and African states. And of course, when we talk about a court, we are talking about an institution. But courts as institutions are also composed of judges, because the court consists of the judges of the court and the staff of the court, which in the case of the International Court of Justice are called the staff of the registry of the court. So that is the court. These are the people who, in a way, compose the court. And if we talk about Africa and the International Court of Justice, we will have to start, first of all, with the composition of the court and Africa. To what extent have African states, African nations, African peoples have participated in the composition of the court, and how many judges has Africa had so far on the bench of the International Court of Justice, because it is the judges who render the judgments, orders, and advisory opinions of the International Court of Justice. And it is, of course, since the judges render these decisions of the International Court of Justice, Africa's contribution comes mainly, or ideally should come mainly, through its own judges, the judges of African origin who sit on the bench of the International Court of Justice. Africa was not one, or I should not say Africa. I should say that there were not many African states that had participated in the at the San Francisco Conference, where the Charter of the United Nations was adopted. There were only Liberia, Ethiopia, and Egypt. Those were the only African countries that were there at the time. Almost all other African states were still under the colonial yoke. So when the first composition of the court and when the first judges of the court were elected in 1946, there was only one African judge, and that was Abdulhamid Badawi of Egypt, because he was also the delegate of Egypt to the San Francisco Conference, and he contributed a lot to the elaboration of the Charter of the United Nations. But that is perhaps for another lecture, because that contribution of Abdulhamid Badawi and of the African states to the elaboration of the Charter of the United Nations is mostly ignored, and nobody really talks about it. But I think we should talk about it as Africans, and we can talk about it in a lecture some other time. So Africa had only one judge out of 15 judges, because the 15 judges are in the statute of the International Court of Justice, that there will be 15 judges at the court. But Africa had only one. And of course, when most of the African countries acquired their independence in the late 1950s and early 1960s, the African countries were not satisfied, and they were not happy with the fact that there was only one African judge at the International Court of Justice. So a second seat was given to the African states. And that is where Isaac Forrester of Senegal was elected to the court in 1964. So then there were two judges from Africa. And in 1968, 69, when for the first time the member states of the United Nations started discussing the Charter of the United Nations, the implementation of the Charter, the interpretation of the principles of the Charter, in order to accommodate the perspectives of international law of the newly independent states, not only African states, but also Asian states, Caribbean states. Then, of course, the African states raised again the issue of the composition of the court, because the composition of the court and whether there should be 15 judges or more than 15 judges was being debated. And most of the member states of the United Nations were reluctant to amend the statute of the court, which is actually part and parcel and is annexed to the Charter, as you know, of the United Nations. So expanding membership in the court, adding new seats to the court, would have required the amendment of the statute of the court, and that was considered difficult by most states. So the member states of the United Nations decided to keep the membership or the composition of the court at 15 judges, but to revise and review the manner in which the seats were distributed and shared by the member state. And that distribution was always some sort of an unwritten agreement. It was never put anywhere that Africa will have only 2, Asia will have 4, or Latin America will have 4. It was not written anywhere. It was some sort of a custom and an understanding, especially among the members of the Security Council, on how to distribute and to divide the seats of the International Court of Justice on a continental basis. So the African states were able, finally, to get that unwritten understanding revised and to be awarded 3 seats at the International Court of Justice. So from 1970 onwards, African states have always had 3 seats and 3 judges at the International Court of Justice. There have been so far about 13 or 14 African judges. I will go through the numbers now, because there have been 3 judges from Egypt, and that was the country, together with Nigeria, that has always had the highest number of judges from Africa at the court. That has so far had the highest number. There is no sitting Nigerian judge at present at the court. There is no sitting Egyptian judge, but in the past, there was very often either a Nigerian judge or an Egyptian judge. And this should, of course, not be a surprise, because they are among the first 3 most populous countries in Africa. Nigeria is the number 1. Egypt, I think, is number 3. So Egypt had so far 3 judges. Nigeria has had 2 judges, no, 3 judges also, 3 judges, one of whom completed the term of the second judge. The second judge, by the way, was Judge Elias, Taslim Elias, who became the first African president of the International Court of Justice. So Nigeria has also had 3 African judges. Senegal is the 3rd country, but it has had 2 judges. Then all the other judges, African judges, that have served at the International Court of Justice came from different African states. And these are Benin, one judge from Benin, one judge from Sierra Leone, one judge, Judge Ranjeva from Madagascar, one judge from Somalia, that's me, one judge from Uganda, Judge Sebutinde, who is still on the bench, and one judge from South Africa, Judge Tladi, who was elected just a year and a half ago. And one judge from Sierra Leone, I don't know whether I mentioned that, Judge Abdul Koroma, and then there were one judge from Algeria, Judge Bijawi, who became the second African president of the court, and Judge Bennouna from Morocco, who retired just a year and a half ago. So these were the judges, the African judges, who served as members of the International Court of Justice from 1946 up to now. And Abdulhamid Badawi served for almost 18 years. And a few other judges served 2 terms, which are normally 18 years, like Abdul Koroma of Sierra Leone and Raymond Ranjev of Madagascar. So you can, of course, expect that, and you must, of course, know, some of you must know also, that these judges brought Africa's viewpoint to the International Court of Justice. And why do we say they brought Africa's viewpoint and African perspectives to the International Court of Justice? Because before the independence of African states were not considered subjects of international law. They were considered objects of international law. They were totally excluded from the applicability of international law because they were colonized. They were colonies. And therefore, at the international level, they were not considered as states. And of course, if you are not a state, then you can't be a subject of international law. And they were excluded from contributing to the evolution and development of the international legal order. That order, however, we must recognize, was not a universal legal order. It was an order that was European-centered. It was an order which was created among the European countries in the 19th century and before, some of it 18th century perhaps. And therefore, it reflected what was known at the time as Jus Publicum Europaeum, or a public law of Europe. But many of the authors at the international level and international lawyers, of course, mostly international lawyers from European countries, referred to it as the law of nations, because the only nations which existed for them were the European nations and the nations which were, of course, created, established by descendants of Europeans in the United States, in Southern and Central and Northern America, and of course in Australia, New Zealand, etc. So those were for them the nations of the world. The others were excluded as nations and as states, although there were, of course, states and nations like China, Siam, which is now Thailand, Japan, the Ottoman Empire, which had a much older and better actually known civilization. India, before it was also colonized by the British, which had an older civilization and which had states and sometimes empires before the Europeans had anything like that. But the Europeans created their own legal order, and they said that it was applicable only among first the Christian nations, and then later among the civilized, because they knew that they could not always claim that this legal order was based on religious identity. So on what should they base it then, if they cannot base it on religious identity? Because that was what they shared mostly. And so they said, we should say that it is actually, it applies among the civilized nations of the world. And of course, they set the standard of civilization, and they defined it, what were the civilized nations of the world. And they excluded any non-European states, and they gave themselves the right and the power to admit those states to this magic circle of civilized nations. So if you were not admitted, you did not belong to it. So first they admitted the Ottoman Empire, and then they admitted Japan, and then they admitted Siam, Thailand, etc. And all this happened at the end of the 19th century and in the early 20th century. But they were not willing to admit an African nation. You know that even at that time, there were already two African states that were not colonized by the Europeans, and therefore whose statehood, because Africa had states and empires, whose statehood was not taken away by European colonization. And these two states were Liberia and Ethiopia. And when the first worldwide, because it was not worldwide, but at least it claimed it to be worldwide, the first worldwide conference aimed at organizing the international society was convened in Paris and in Versailles immediately after the First World War. Almost all the independent states of the world, and even states that were not independent, for example, the British dominions at that time. South Africa was a British dominion. India was a British dominion. Australia was a British dominion at the time. New Zealand was a British dominion. Even the British dominions were invited. But all the independent states of the world were invited to that conference. And I think the only exception, or one of the exceptions, few exceptions, was Ethiopia. And you ask yourself why. Ethiopia had been independent for a very, very long time. Ethiopia had defeated at the Battle of Adwa a European power which was trying to colonize it. And therefore, Ethiopia had a statehood. Ethiopia was a state. It was never colonized. Why did they not invite it? Because they decided by themselves that it could not fit into their standard of a civilized nation. And therefore, it could not be brought into this magic circle of civilized states who met in Versailles in order to write the pact of the League of Nations, because they were setting a framework for a new international legal order, which they thought could bring about peace among the nations of the world. They, of course, established the Society of Nations, and they established it with the Society of Nations, with the League of Nations. They established with the League of Nations the first International Court of Justice, which was known at the time the Permanent Court of International Justice. But, of course, there was no universality in the legal order. And a legal order which lacks universality, at the international level, lacks legitimacy. Because you can't have an international legal order when more than half if not 2/3 of the peoples of the world are colonized, are oppressed. Their human rights are completely ignored, and they have no voice in the creation of that legal order. And it was not and could not be a legitimate legal order because in Versailles, when Japan, that had been admitted shortly before to the magic circle of the civilized nations, suggested and proposed that the pact of the League of Nations should actually include a clause on the equality of races. That's how the Japanese delegation put it, a clause on the equality of races, by which they meant, of course, equality or equal rights of peoples, that all the peoples on this planet, all the nations of the world, all the ethnic groups of the world have equal rights. And that is a basic notion of legitimacy and justice, because there is absolutely no people in the world which is inferior to others. No nation in the world which is inferior to others. And if you cannot recognize that, then you don't have a legal order. It is as though you had domestically a legal order which said and which treated and which actually consecrated that certain groups in the country were inferior to others. But many of the participants could not accept that. They could not accept the equality among the races and nations of the world. And so they rejected it. And so that is the kind of legal order that was established at the time. And that is why I personally believe, maybe many people do not share that view, but I personally believe that there was nothing that we could be referred to at the time as international law. Because international law, in order to be a law among nations, and in order to be a rule of law that governs relations among nations, has to be universal and has to be legitimate and has to treat all the peoples of the world with dignity and equality. Because otherwise it's not law. It is simply something that someone has created for his own convenience. And therefore, for the first time, it is with the Charter of the United Nations that we have some sort of a basis, some sort of a foundation of the rule of law among nations, and therefore a system of law which had an aspiration to universalize. And why do we have in the Charter, and how can I justify that it is in the Charter only that we have this, the foundation of this system, which was ready and which was aspiring to universalize, because of the principles of the Charter of the United Nations. First of all, the Charter consecrated in its preamble respect for human rights wherever human beings are, and because of their humanity. Not the kind of human rights declarations that European countries use it to adopt, and which were applicable only to their citizens and to the people whom they consider it to deserve it, but a human rights system which is based on the human dignity. This was the first time. Secondly, it was the first time in which a universal or an instrument with a universal aspiration was adopted by the nations of the world, which banned, prohibited the use of force in international relations. Third, it was the first time that an international instrument which recognized equal rights, the principle of equal rights of peoples, and the principle of self-determination of peoples. And that is how it is expressed in the Charter, equal rights and self-determination of peoples, because the two notions are connected, equal rights and self-determination of peoples. If you recognize equal rights of peoples, then you cannot subject one people to the domination of another. A people cannot colonize another people. And so it actually contained the seeds, not only of self-determination, but also of the outlawing of colonialism, which was legal under the old order, call it international law or the Jus Publicum Europaeum of the 19th century, early 20th century. Colonization was considered legal, not illegal. But under the Charter, colonization was gradually outlawed. And it is in 1960, with Resolution 1514, adopted by the United Nations General Assembly, that it was officially, as an interpretation of the principle of equal rights and self-determination of peoples, that it was officially declared as illegal and outlawed by the nations of the world. And that resolution is now considered as part of customary international law, and the International Court of Justice has on several occasions insisted that it is part of customary international law, and has even recently said that it is part of jus cogens. The right to self-determination is not only a customary right, it is part of jus cogens, especially under regimes of occupation, because no people should be occupied by another. It is illegal. So that is how the system evolved. And therefore, the African countries saw, when they became independent, saw in the system which was created by the United Nations Charter as a system which contained the seeds of a future international legal system, of a future rule among nations, which could be further developed, universalized, could apply to all nations, and could, of course, be reformed. And that is what they did from the 1960s onwards. So there was, on the one side, resolutions like 1514, which were sponsored by the African states at the UN General Assembly, and therefore gradually brought into the system the interpretation of the rules of the Charter, which could be used to create equality, to prohibit violence and wars among nations, to admit and recognize the fight for independence, liberation, and emancipation, and to create a kind of a level playing field for all nations at the economic and social level, and also at the political level, equality among nations. And so one instrument for helping evolve and develop the system was the United Nations General Assembly's adoption of interpretative resolutions. The second instrument was the convening of codification conferences. But they were not only codification conferences, because the European countries and the countries that, of course, existed as independent states before the Charter of the United Nations were trying to impose the customary norms which applied amongst themselves as international legal norms. But the African countries, the Asian countries, the Caribbean countries, and to a certain extent, the Latin American countries also, as a global South, wanted to reform that system. And in order to reform that system, they had to engage not only in the codification of certain norms and rules, because they themselves saw interest and importance in those rules, like diplomatic immunity, immunity of jurisdiction. These were rules that the newly independent states felt comfortable with. But there were a lot of other rules with which they did not at all feel comfortable, including even rules on the conclusion of international treaties. So they wanted to engage not only in codification, but also in the progressive development of international law. And so they put together conferences, and they asked the United Nations to convene conferences on the codification and development of international law. And they used the International Law Commission also for that purpose. And the International Law Commission was putting forward draft conventions, draft treaties, which could be negotiated at a universal conference and which could not only codify, but also progressively develop the norms of international law. So that was the second a way of reforming and advancing a universal system of international law. The third system, which they wanted to engage with in order to reform the system, was to reform the law applied by the International Court of Justice. And therefore, because the International Court of Justice as a court of law also contributes to the progressive development of international law. And there are a lot of legal rules, legal norms, which are now part of international law and recognized by all the nations of the world, which have come to fruition thanks to the jurisprudence of the International Court of Justice. But because the International Court of Justice up to the 1970s was composed mainly of judges from those countries that resisted the change to the old system, the court did not contribute to the development of international law. And I will give you a few examples. When Africa, for example, had 1 or 2 judges only at the court in the 1960s, the Ethiopia and Liberia brought the Southwest African cases. They are well-known cases. They were cases concerning the occupation by South Africa of Namibia, which was at the time known as Southwest Africa. And since they were the only two African states that were members finally of the League of Nations, which entrusted to South Africa at the time the mandate over Southwest Africa or Namibia, they felt they had an interest, a legal interest in bringing the case and a legal standing. And therefore, they brought the case in order to argue that the system of mandates had come to an end. And therefore, the presence of South Africa in Southwest Africa was illegal. And they wanted the court to confirm that and to say that, of course, the people of Namibia were now, like all the other peoples, entitled to the right to self-determination. But the court, whose composition was still of judges who were of the old mentality and of the old school, did not even understand that there was a right to self-determination that had emerged at the international level. They still believed that people could be colonized, people could be occupied. And therefore, the majority of the court said, Ethiopia and Liberia do not have a legal standing, and therefore we dismiss the case. That put an indelible stain on the reputation of the court. And for almost 20 years, no African or Asian country brought a case before the International Court of Justice. The court was boycotted almost because it was considered a reactionary court, a court which did not recognize the realities in the world, that the international society had changed. And when the structure and the composition of a society changes, the law adapts. The law has to adapt. Otherwise, the law is outdated. But the judges live it in the world of some sort of an outdated law, but they did not recognize it. They thought that they still live it in the same world as the 1950s, but that was finished. And so nobody actually was coming. And the court was discredited because the court was not, like the rest of the world, contributing to the development, to the evolution of international law, and to the emergence of a new legal order, a new rule among nations, rule of law among nations, which was being concretized at the international level, and to which the newly independent countries were contributing. So these newly independent countries stayed away from the court. And, you know, for a long time, the court had maybe one case before it, two cases before it, whereas today the court has 24 cases pending before it. And so the trust and the confidence in the court has returned. And how did it return? Because the General Assembly of the United Nations decided in 1970 to come back to the International Court of Justice and to request an advisory opinion on Namibia, on the same subject which the court did not want to deal with in 1966. And the court realized that this was its chance and that it should immediately seize the opportunity. And the court announced for the first time that it should apply the principle of equal rights and self-determination of peoples, and that the recent developments at the international level, and that's how they refer to it, recent developments at the international level made it necessary for the court to recognize the evolving nature of the law. And therefore, the court said that South Africa was illegally occupying Namibia, and that this occupation had to come to an end because the people of Namibia had a right to self-determination. And this was really a major change in the international scene and in international law. And in 1974, when another advisory opinion was requested by the General Assembly on Western Sahara, the court reinforced also its views on the matter and clearly and explicitly recognized that now there was a right to self-determination at the international level, which was of a customary nature, which had become of a customary nature. In other words, which had to be recognized by all the nations of the world. And that such nations had actually an obligation which corresponding to that right to recognize the right to self-determination. And so the court had changed it. And for the first time since the 1970s, and from the 1970s, as I said earlier, there were 3 African judges at the court. And from that moment, the wind of change affected the court also. It came to The Hague and affected the court. And therefore, in the late 1970s, the African Union recommended to 2 African states that had a territorial dispute. They were Upper Volta. It was still called Upper Volta, but today it's called Burkina Faso. And Mali, the African Union, advised them, and they did in the early 80s, to come before the International Court of Justice to settle their dispute. And the African nations gradually came to accept that the court was now ready to apply, because that is what actually kept them away. It is not that they did not like the court as an institution. No, not at all. I mean, they liked the concept of settling disputes peacefully through the law, and they subscribed to it. But the issue for the African states was which law? What would be the applicable law? And now, for the first time, they felt at peace that the reformed international law, that the evolving international law, that the international law that has been devised, changed through the codification and progressive development conferences, through the resolutions of the United Nations, through African doctrines, even like the Nyerere doctrine. You know that there was a treaty on the succession of states to treaties, which was elaborated by the International Law Commission, and which became afterwards an international treaty. How states after independence should succeed to treaties that existed before their independence. And of course, by that time, President Nyerere of Tanzania had established his doctrine on succession to treaties. And African states subscribed to that. Not only African states, but Caribbean nations also. And so when the conference was convened in Vienna on succession of states to treaties, those groups of states made their voices heard and presented the Nyerere doctrine. And this was taken on board, and this was actually recognized. So the court and the African states now were aware of these changes, and that these changes came to the shores of The Hague in the North Sea in Europe, and that therefore the court was ready to apply this reformed, newly developed international law that was emerging at the international level. And so Mali, Burkina Faso came here. Libya, Tunisia came here for the delimitation, maritime delimitation, the delimitation of their continental shelf. And gradually other developing countries, other third world countries started coming back, particularly Latin American countries first, and then Asian countries. And now, as I told you, there is a widespread universal trust and confidence in the work of the court and in the law applied by the court. Imagine the court in the 1960s receiving a request on Chagos Islands or archipelago, and whether the separation by the British of Chagos from Mauritius was legal or illegal. The court would have perhaps said, no, it was legal, it was fine. The British had the right to separate it from Mauritius. But it came in the 21st century, and the court said it was illegal. The British had no right to separate part of the territory of Mauritius from the rest of Mauritius, and the United Kingdom has to withdraw from the archipelago. And that's what they are doing now. They are withdrawing from the archipelago, and they are giving it back to Mauritius. So the law has changed. The applicable law has changed. The manner in which the court deals with those issues has changed. But, and I will conclude here because I think I have been speaking for almost an hour and a half, but there is an unfinished business. And I have recently written a separate opinion in the case between Gabon and Equatorial Guinea on that unfinished business. That unfinished business is that the court has not fully abandoned it. It has not fully put aside the use of certain concepts of the jus publicum Europeum, concepts which were used in the colonization and oppression of African states, and that the court actually brings them up and applies those concepts in maritime and territorial delimitations between African states. Because when it comes to the delimitation of frontiers, these states themselves, through their council, and we know who the council of the African states before the International Court of Justice are, there are hardly any African council appearing before the International Court of Justice for their status. The council appearing for African states are mostly European and American council. And through their council, these African states dig up colonial documents, colonial concepts, and put it before the court. And sometimes actually in a compromise, in a special agreement between two African states, which agree on settling their peaceful dispute peacefully and submitting it to the International Court of Justice, you find in the compromise that the African states themselves are saying, we want those concepts to be applied in the resolution of our dispute, and you wonder what's wrong with them. And so the court digs up those concepts. And that is the reason why I wrote my separate opinion, not because I disagreed with the judgment of the court. I think the judgment of the court in Gabon, Equatorial Guinea was correct. And therefore I voted for the operative paragraph of the judgment, and I agreed generally with the judgment. But the judgment continued to use colonial terms, to use colonial concepts, to use colonial rules like prescriptive acquisition of territory. And if you go through the judgments of the court for the last 20 years on disputes, whether they are maritime or territorial disputes between African states that were brought before the court, you will find all kinds of language of colonial character and nature, like that Germany had sovereignty, had title, colonialism, occupation of territories, oppression of peoples could never give title to the oppressor, to the colonizer, to the occupier. Under what law? Of course, they will say under international law of the time, but international law of the time did not apply, as I said at the beginning, to Africa. It did not apply to Africa because Africa was considered to be outside the circle of civilized nations. So you cannot apply the principle of intertemporal law to African disputes and say the law that was recognized in Europe applied to you also. On what basis? We did not even know about its existence. So how could it apply to us? We did not contribute to it. And it did not for us exist. And so how can you say that France had a title to the territory of Mali or Senegal or Burkina Faso? It had no title. It was just occupying illegally the territory of others. And that is what should be applied. So that is actually the unfinished business. And I have been fighting to make sure that the court abandons this also in the same way that it abandoned the old international law that was established in Europe as Jus Publicum Europaeum, but there are still vestiges of that law that the court now and then digs up and applies, because the African states themselves think that it is in their interest that it should be applied, but it's not in their interest. And they should not accept to be advised that it is in their interest that it should be applied, because somehow they recognize colonial law to be applied to their relations. And there is no reason why African countries should recognize in the 21st century that colonial law should be applied in their relations. For example, if I take only one example, the principle of uti possidetis iuris, which is applied among Latin American states, because Latin American states are all offshoots of the Spanish Empire in America. And therefore, they recognize it at the time of their independence in order to stabilize the frontiers amongst themselves. They recognized the applicability of Spanish administrative law to the delimitation and recognition of their respective boundaries. And they actually took on board that Spanish administrative law, because it was also, they looked at Spain as their parent country, the country which gave birth to them. And therefore, the law of that country could, of course, be inherited by its offspring, which were the Latin American countries. But how can African countries consider themselves the offspring of their colonial, the colonial powers which oppressed them? When Boutros Ghali was asked, Boutros Ghali, who was a famous African international lawyer, Egyptian international lawyer, who became Secretary General of the United Nations, when he was asked the applicability of the principle of uti possidetis iuris to Africa, because of the Cairo resolution on boundaries, and the principle is adopted in 1963 at the Addis Ababa conference, creating the Organization of African Unity. And he participated in both of them. He replied that we had always, as Africans, known about uti possidetis iuris as a principle which was of a regional character and which was used by Latin American states. But we as Africans did not want to adopt it because we did not want to ratify the Berlin Conference. We did not want to say, yes, the decisions and the law which came out of the Berlin Conference and its successive development is applied to us also. No, he said we did not want to legitimize colonialism and the Berlin Conference. And so we never wanted to apply uti possidetis iuris to ourselves. But unfortunately, there are African states that bring their disputes to the International Court of Justice and then argue that uti possidetis iuris applies between the African states. You don't know how to address such an issue. It's very difficult, very difficult. I think we come to the end, and I thank you very much. It is more than 30 minutes, 1 hour and 30 minutes is, and I thank you for your attention. If you are still all there, and some of you have not left or fallen asleep, thank you.
Judge Yusuf.
I'm done.
Okay, can you hear me?
Yes.
Okay. That was a wonderful lecture, very powerful, very insightful, and I'm sure that everyone benefited from it. Actually, you've only been speaking for an hour, so we have an hour and 7 minutes. So we have time for a few questions, and I want to save a little bit of time to talk about the coalition. First question, can you talk about the recent judgment in the case of Sudan against the United Arab Emirates?
What do you ask me about? Is there a specific question, or you want me to talk about the entire case? Because I wrote a dissenting opinion, and I think that anybody who is interested in my views about the case can read my dissenting opinion.
Perfect. We have many questions. I will move on.
Yeah.
Okay, let's see. What measures could the court adopt to enhance the accessibility, procedural efficiency, and equitable participation for states that may face structural limitations in sustaining extended litigation?
The court has actually thought of that a long time ago, and a litigation before the International Court of Justice is not as costly as litigation before arbitral tribunals, because arbitral tribunals charge states for their use of the tribunal, and always cost much more than the International Court of Justice, because states can come before the International Court of Justice and have a couple of counsel or a few advocates and lawyers and argue their case, and that's it. But of course, there are those states, and particularly the least developed countries of Africa or of the Caribbean or of Asia and of Latin America, that may not be able to afford even that minimum cost of appearing before the court and submitting disputes before the court. And so the court created a fund at the United Nations, asked the United Nations Secretariat to create a fund which would help and subsidize the least developed countries that want to bring disputes before the International Court of Justice. And this fund actually covers a lot as far as least developed countries are concerned when they come before the International Court of Justice. That facilitates for them bringing cases before the court, and of course gives them an easier access to justice at the international level.
What hope can Africa have in relation to the court's recent opinion on climate justice?
A lot, because if you have really paid attention to the comments, or if you have even read the advisory opinion on climate, I think that you will see that for the first time in the history of humanity, the court has clarified and elaborated on the rights and obligations of states with respect to climate change. Up to now, there were, of course, individuals, states, organizations that argue with one way or the other. But there is today an authoritative pronouncement on the obligations of states as far as the climate is concerned. And we all know that these obligations are to be particularly fulfilled by those who are at the origin and who have contributed most to the phenomena at the source of climate change. So I think that the African states, in coalition with other states of the world, whether it is at the United Nations, whether it is at the COP, the Conference of Parties to the climate treaties, or whether it is in other fora, can use these norms and rules clarified by the International Court of Justice to advance their cause and also to prevent further damage to our planet.
How can issues relating to the execution of judgments and decisions of the International Court of Justice be addressed?
You know, I am asked that question very often because I think that people sometimes confound or conflate the role of courts and the role of the executive or the enforcement authorities. If you look at your own country or at the legal system of any country in the world, I'm talking about the domestic legal system, no court is asked about the enforcement of its judgments. The courts do not run after their judgments and say, we want you to enforce our judgment. The courts issue judgments, and it is other organs of the state which enforce such judgments. The international legal system, unfortunately, is not mature enough to have that kind of enforcement authorities. We have enforcement authorities, but enforcement authorities which are fragile. And the most important enforcement authority, which was created under the Charter of the United Nations, is the Security Council of the United Nations. But the Security Council of the United Nations is not only fragile, it is actually vulnerable to the veto power of the 5 permanent states. And therefore, it is a very imperfect and very weak system of enforcement. And the weakness of the system of enforcement comes from the fact, number one, that the universality of international law, as I said earlier, is a recent phenomenon. And number two, that states are sovereign equality. And therefore, a group of states or one state cannot impose necessarily something on one state or another group of states. It's difficult from a legal point of view, even if they have a judgment. So we need to review the institutional system, not the legal system. The legal system is functioning. The court is functioning. States are coming before the court for the clarification, interpretation of the rules. The court does it, but the institutions to enforce them are not yet perfect. They are not yet always functional. They can now and then become functional because there is consensus among nations at the United Nations, but they can easily become dysfunctional also, and therefore not able to have the judgments of the court enforced. And that is the system as it is today. Either we have to accept it for what it is, or we have to try to develop it and to perfect it and to make it better.
I would like to ask you a question, if I may.
Please.
What are your views concerning the importance and the urgency of all African nations signing and ratifying the recent African Union Convention on Ending Violence against Women and Girls?
It is of the highest importance. It is really something that requires utmost priority and urgency. And I think that African states cannot continue to put laws on the books, just to adopt laws, to adopt conventions, to adopt protocols, to adopt treaties in Addis Ababa, and then forget about them. No, You can't forget about them. Otherwise, don't adopt them. There are more than 60, I think 70 now, treaties, conventions, protocols that have been adopted by the African Union and its predecessor, the Organization of African Unity. And many of them have not yet been ratified. But look at this one that Virginia has just mentioned. It is of extreme importance that this convention and other conventions and treaties that are still in the drawers of bureaucrats in African states should actually be ratified and taken to the parliaments of African states, because Africa will not have a viable and effective public law which deals with issues like violence against the girls and against women unless this instrument is ratified. And it is high time it should be ratified. And I hope all those who are listening to me today will work to that end, will work for that objective, will push their states, and will ask them that they should immediately ratify this convention.
Thank you so much for your support. Before we end this session today, I would like to briefly discuss the Coalition on African Treaties ratification. This was the result of your inspiring lecture and the lectures of the others during our last workshop on African treaty ratification. The registration form for this seminar included a question asking participants if they would be interested in joining a coalition to promote African treaties ratification. 1,357 participants in 50 African countries joined the coalition. This was within about 2 weeks. This was a strong indication of broad support for such a new initiative. The next step was to create a petition calling on all African countries to sign and ratify the AU Convention on Ending Violence Against Women and Girls. I consulted with the AU Legal Counsel and with Ben Kioko, the former vice president of the African Court, before proceeding with the petition. The AU Legal Counsel was the first person to sign the petition in her personal capacity. Ben Kioko was the second. The petition was sent to all participants who had joined the coalition. The goal was to achieve 100 signatures during the first week to 10 days. We exceeded this goal. The second goal was to achieve 500 signatures before this seminar began. I checked on Saturday morning, 2 days ago, and we only had 366 signatures. I began sending emails to the coalition members by country to facilitate national cooperation, to ask for volunteers to serve as national coordinators, and to ask for their help in getting signatures. Since then, since Saturday morning, I have only had time to send these emails to 20 African countries. I will be sending them to the rest of the countries as soon as I can. But nonetheless, with the additional support from these 20 countries, less than 50% of the AU member states, as of this morning, 750 signatures, which is amazing.
That's amazing.
My goal for tomorrow is 1,000 signatures. I would encourage all of you who have not yet signed the petition to do so now by clicking on the petition in the chat room, which also contains translations of the petition in Arabic, French, Portuguese, and Spanish. Later this week, we will be discussing the national coalition groups and how they can support this cause, because this has to happen on the ground. It has to happen at the national level. The Pan-African group is very important, but the real hard work needs to be done at the national level. And also, this is something that we have discussed before. We are planning to have 3 town halls, one in English, one in French, one in Arabic, with leading experts on the convention, who will provide a brief 30-minute introduction to the convention. The next 90 minutes will be for questions, concerns, and exchange of view directly between the participants and the moderator. The Special Rapporteur for the AU, Special Rapporteur for Women, has agreed to serve as the English moderator. The AU Legal Counsel, Hajir, has agreed to serve as the Arabic moderator. There is a wonderful person, I think her name is Benetta Diop. She's a leader in this field. As soon as I can get her contact information, I will be asking her to lead the seminar in French. Before concluding this lecture, I would like to inform the participants that you will be joining us for the next seminar on democracy and good governance in Africa to give a lecture on the African Union and change of government on the continent. Finally, we still have 7 minutes. Finally, I would like to ask the participants to join me in expressing my deep appreciation to you, Judge Yusuf, for your years of dedication to international law in the service of justice, of peace, and humanity as you retire from the International Court of Justice after almost 2 decades later this month. I sincerely hope that this does not mean that you will be retiring as a lecturer for the African Law series, because there is still so much to learn from your academic knowledge, your experience, and your wisdom. Perhaps we can organize a lecture on Africa's contribution to drafting the United Nations Charter at the San Francisco conference. That is just one idea. I would also like to briefly recall that when we were in Addis a few years ago, one of the participants asked you, how long would it take to achieve the goals of Pan-Africanism? And you responded that it would take years and an army of lawyers. After your lecture, I never told you this. This participant came up to me and said, I would like to join Judge Yusuf's army. And I said, sir, he doesn't have one yet. Now you have your army of lawyers who are following in the footsteps of the Pan-Africanists. And I have complete faith that with their dedication, with their commitment, with their hard work, we will achieve our goal, which is 55 signatures by February 16, the 1-year anniversary of the convention. Now that I've done all this talking, would you like to make any concluding remarks before we end the session today? And thank you so much for taking the time to join us. It is always a pleasure.
Virginia, I think that the most fitting remark that I have to make is to thank you, to express our gratitude, not only my gratitude, but also the gratitude of the participants, the gratitude of the African Institute of International Law to you, because you are not an Africanist, you are an African, and you are, yes, and you are promoting Pan-Africanism better than actually many African leaders and African intellectuals. And therefore, we owe you a debt of gratitude, really, a profound debt of gratitude. And you are a general in the army, which you just mentioned, a great leader in that army. And of course, I will not only continue to mobilize with your assistance, with your support, that army, because, of course, we have just touched the surface of implementing Pan-Africanism and the ideals of Pan-Africanism with our Pan-African organization, the Organization of African Unity first, and now the African Union. We have adopted a lot of instruments which should normally facilitate the achievement of the goals of Pan-Africanism. But as we said earlier, those instruments, many of those instruments are lying in the drawers of bureaucrats in African states, and I hope that the participants, their colleagues, their peers, their friends will help us to take them out and to make sure that they are adopted by their respective parliaments so that we can get closer nearer to the objectivists and idealists of Pan-Africanism. And you are contributing a lot to that. You know that Pan-Africanism started with people from your continent.
Huh.
Americanists, African Americanists, and Caribbean, Caribbeanists of African origin. And now the implementation, approaching the idealists of Pan-Africanism, taking all these instruments which will facilitate a Pan-Africanism to their realization is being pushed by you from the United States of America, an international lawyer from the United States of America, and I find that really extremely, extremely important and heartwarming. So thank you very much. And I hope you will not get tired of this struggle. You will continue it. It is worthwhile to continue it and to fight for this worthy ideal, noble ideal. Thank you.
Thank you for your kind words. Thank you for your inspiration. And I think as a friend of the family of African nations, I'm happy and proud to promote the values of Pan-Africanism, which I fully support. So I hope you enjoy your well-deserved retirement, and I look forward to seeing you in December. Thank you so much for your time and your wonderful lecture, and thank you for your support for the convention. I appreciate it.